The massive auditorium at the University of Chicago Law School grew entirely quiet. A palpable sense of expectation filled the room while Judge Richard Posner, a highly esteemed American judicial icon, remained rigidly seated at the speaker's stand. His piercing gaze, famous for detecting any weakness in legal reasoning, currently displayed obvious skepticism. Just minutes before, he had publicly belittled Representative Jasmine Crockett, labeling her as merely an elected official pretending to be a legal professional. However, currently positioned with grace and assurance at the mic, firmly gripping a dense binder of case documents, Crockett prepared to permanently alter the atmosphere of the gathering. "Judge Posner," she initiated tranquilly, her tone unwavering, authoritative, and articulate, "you challenged my professional qualifications and implied I am merely an elected representative pretending to comprehend jurisprudence." She hesitated briefly prior to resuming. "Please permit me to present information to you and this esteemed crowd that could potentially alter your perspective." The tension was thrilling as all attention in the venue centered upon her, while jurisprudence scholars tilted ahead enthusiastically, academics repositioned their spectacles, and court reporters readied themselves to document each syllable. This represented no typical university gathering. Rather, it functioned as a battle of minds and an examination of vocational legitimacy, destined to emerge as a highly memorable occurrence in contemporary judicial lore. Over the subsequent 20 minutes, the ensuing events would render Judge Posner mute, boost Representative Crockett's standing as a brilliant jurist, and ignite a fiercely debated confrontation within scholastic law circles. To accurately comprehend the importance of this confrontation, one must initially analyze the dual influential personalities situated at its core. Magistrate Richard Posner had dedicated over 3 decades serving as an exceptionally prominent federal adjudicator in the United States. At 84 years old, his influence across the judicial landscape stayed immense, having drafted upwards of 3,000 court rulings and published beyond 40 texts regarding jurisprudence and financial theory. Recognized for his exceptionally acute intelligence and pragmatic methodology, Posner had cultivated an image of genius paired with straightforward candor. Advocates praised his perceptiveness, while detractors charged him with egotism. Nevertheless, almost all parties concurred that he represented a premier analytical mind of his era. Even after stepping down from the Seventh Circuit Court of Appeals, his authority persistently molded judicial training throughout the country. Colleges continuously instructed students on his groundbreaking verdicts, and his publications stayed compulsory curriculum within advanced degree courses. Whenever Judge Posner discussed jurisprudence, individuals paid close attention. However, notwithstanding his accomplishments, Posner maintained an enduring contempt for elected officials asserting judicial proficiency. For decades, he heavily condemned those he termed partisan attorneys, meaning public servants who seemingly utilize their Juris Doctorates for validation while discarding genuine analytical reasoning for legislative expediency. From his perspective, a distinct boundary existed dividing active attorneys dedicated to trial advocacy from public servants who simply held the designation. Positioned at the opposing end of this mental contest stood Representative Jasmine Crockett, who honorably served the 30th Congressional District of Texas. At 43, Crockett had previously constructed a formidable vocational path prior to joining government, establishing her legacy as a civil liberties lawyer advocating fiercely for fairness and parity. As an alumna of the University of Houston Law Center, she had devoted more than 10 years to litigating cases within the Texas judicial system. Still, her transition into government caused certain conventional academic jurists to doubt if she currently fit within the category of authentic legal practitioners, a fact that very few individuals comprehended, encompassing Judge Posner personally, was that Crockett had never actually abandoned the active legal profession. Even while fulfilling her congressional duties, she persistently managed specific unpaid legal matters concentrating on fundamental constitutional protections and personal freedoms. A significant portion of her attorney duties occurred silently and lacking media attention, yet her documented history communicated profoundly. She had secured major victories that preserved fairness for disenfranchised populations, and showcased a profound comprehension of intricate judicial doctrines. This currently renowned altercation occurred over the course of an academic panel designated as Jurisprudence and Government in Contemporary America. The gathering convened national magistrates, esteemed academics, and vital legislative leaders to converse about the ways analytical jurisprudence intersects with governmental policymaking. That which commenced as a scholarly convention was preparing to transform into a substantially more heated situation. Judge Posner served as the primary orator, and his lecture carried the title regarding the deterioration of judicial reasoning within legislative conversations. His address focused on what he perceived as an increasing pattern of elected representatives twisting statutory contentions for electoral advantage. Once the audience inquiry segment commenced, Representative Crockett walked up to the audio equipment. She had received an invitation to offer a legislative viewpoint, yet she desired to challenge Judge Posner's premise exclusively from a judicial standpoint. Her initial query proved intricate and perceptive, alluding to a lately issued Supreme Court ruling regarding constitutional analysis. Posner's reply, nevertheless, came across as exceptionally abrasive. He dismissed her inquiry entirely, implying that government officials seldom comprehend the genuine intricacies of foundational statutes since they concentrate heavily on legislative results rather than judicial logic. The underlying stress within the auditorium became distinctly noticeable. It forces a person to consider whether they have ever observed an individual's abilities or knowledge being thoroughly undervalued, only for that person to completely reverse the situation. Such instances where the unexpected challenger emerges victorious remain genuinely memorable. Crockett refused to retreat, proceeding with an additional inquiry, on this occasion regarding appellate processes and their possible impact on upcoming statutes. Yet again, Judge Posner rejected her assertion in a highly patronizing manner. He insinuated that her query demonstrated a deficiency in comprehending the practical operations of the national judicial system. Subsequently arrived the comment that completely shocked the whole auditorium. Staring directly toward Crockett, Judge Posner stated, "Representative, with complete deference, you represent what I label a fraudulent attorney. Certainly, you possess a legal diploma. However, you currently operate strictly as a legislator. You have forsaken earnest judicial analysis in exchange for governmental dramatics. I highly question if you have entered a tribunal or drafted a significant court document in multiple years." A unified, sharp intake of breath echoed across the room as academics repositioned uncomfortably in their seats and jurisprudence pupils traded anxious looks. This ceased to be a scholarly evaluation. Rather, it functioned as a direct assault regarding Crockett's intellect and vocational honor. Numerous elected officials might have responded protectively or attempted to validate their professional background. Nevertheless, Jasmine Crockett executed an action that was completely distinct. She grinned gently, strolled over to her chair, and retrieved the substantial binder she had carried inside. The crowd could sense that an exceptionally significant event was preparing to unfold. The subsequent occurrence would not simply quiet a highly renowned American magistrate, but additionally permanently alter public perception of Jasmine Crockett, framing her not merely as a legislator but as an astute, courageous, and exceptional jurist who rejected being undervalued. "Judge Posner," Crockett initiated as she navigated back toward the mic, maintaining a tranquil yet resolute vocal tone, "I value your candor, and I believe this instance provides an ideal opportunity for a sincere conversation regarding the true definition of holding judicial mastery and the actual reality of operating as an active counselor in contemporary America." The spectators instantaneously grew completely quiet once more. A specific quality regarding her inflection felt distinct, remaining collected while projecting immense strength. Every individual could perceive that this would not constitute a standard legislative rebuttal packed with rehearsed rhetoric. She did not intend to protect her reputation relying exclusively on spoken language. The action she prepared to execute would take every person, encompassing Judge Posner, entirely by surprise. Utilizing intentional precision, Representative Jasmine Crockett unsealed the dense binder she had transported up to the platform. The crowd observed the meticulous organization within, featuring piles of documents divided by tinted markers D and secured similarly to official tribunal submissions. It became immediately apparent that this item was no theatrical accessory, rather it represented the exhaustive labor of a dedicated active attorney. Judge Posner, she proceeded while maintaining direct eye contact, you stated I have avoided courtrooms for several years, asserted I ceased drafting complex case filings, and practically labeled me an illegitimate counsel. Her inflections stayed consistent, yet an undeniable fortitude resonated throughout every single syllable. I wish to address those allegations not utilizing grandstanding but through tangible proof. She extracted the initial record directly out of her portfolio. 3 months prior, I presented oral arguments in front of the Fifth Circuit Court of Appeals regarding Henderson versus the Texas Department of Education. Thus, the litigation concerned fundamental statutory issues regarding equal protection and educational financing. By displaying the document for the entire room to observe, she remarked, "Here is the filing I independently drafted and submitted. It references 47 national rulings, provides novel foundational interpretation, and introduces fresh perspectives regarding the 14th Amendment's intersection with regional scholastic protocols, which the tripartite judicial panel endorsed without dissent." An observable alteration washed over Judge Posner's countenance as he tilted ahead marginally, his condescending look vanishing while genuine interest started dominating. "However, that represents merely a single instance," Crockett articulated, pulling forth an additional record. "Half a year ago, I advocated for an alliance of electoral equality proponents within the National District Tribunal during Martinez versus Dallas County. This lawsuit contested recently implemented electoral regulations that disproportionately harm disenfranchised neighborhoods. Behold the petition requesting a preliminary injunction, which I authored myself." Pivoting back toward Posner, she proceeded self-assuredly, "This request necessitated profound examination of Supreme Court history regarding ballot access, numerical metrics detailing adverse effects, and foundational logic rooted in the Equal Protection Clause alongside the Voting Rights Act." The presiding national magistrate did not simply approve our request, but additionally praised the excellence and lucidity of our statutory postulations. The spectators remained mesmerized while jurisprudence pupils scribbled hurried notations and academics murmured among themselves in sheer shock. Nobody anticipated such an event. The representative previously ridiculed as a fraudulent attorney was currently systematically validating her legitimacy using undeniable proof. Nevertheless, Crockett was nowhere near completion. She grasped a third record, considerably denser than the prior materials. During the previous year, she stated, I managed an unpaid migration lawsuit titled Ramirez versus the Department of Homeland Security. Such litigation required an intricate comprehension of bureaucratic regulations, fundamental procedural fairness, and global pact responsibilities. She elevated the paperwork marginally, noting, this submission spans 89 pages and incorporates novel judicial assertions previously unargued within national tribunals, analyzing the correlation connecting refugee safeguards and fundamental liberties for domestic units. The overseeing adjudicator characterized it as outstanding judicial academics and decided favorably for our plaintiff. At this juncture, Judge Posner ceased concealing his response. His gaze remained glued to the documents, having swapped his preceding hubris for authentic intrigue. An individual possessing decades of experience assessing judicial postulations could immediately identify the validity of the materials he witnessed. However, Judge Posner, she articulated smoothly, you did not merely scrutinize my latest attorney endeavors. You additionally asserted that elected officials similar to myself lack comprehension regarding the genuine operations of national tribunals. She turned toward a different segment of her binder, extracting a collection of processed records. Permit me to elucidate upon that matter additionally. Elevating the pile toward the crowd, she resumed, throughout the previous 24 months, despite working completely as a legislator, I have submitted documents to national tribunals spanning Texas, Louisiana, and Illinois. I have presented requests to commissioners, regional adjudicators, and review boards, I have secured preventative orders, defeated dismissal requests, and victoriously challenged negative decisions. The quietness across the auditorium intensified. Disputing the reality proved impossible. These represented authentic lawsuits, actual submissions, and legitimate triumphs. Zero aspects concerning the material she displayed could reasonably be rejected as legislative theatrics. Furthermore, most crucially, she appended, each individual lawsuit was managed without compensation. I refuse to accept any monetary charges since my governmental income permits me to advocate for individuals lacking alternative means to secure competent national trial representation. Judge Posner took off his spectacles and started cleaning them using a cloth, an action widely recognized by his peers as an indicator of profound contemplation. He had obviously undervalued her capabilities. Next, Crockett extended her hand toward a concluding file. Judge Posner, she stated, there remains a final lawsuit I trust you will deem exceptionally significant. She elevated a secured application. Exactly 3 weeks prior, I submitted this petition for certiorari to the United States Supreme Court regarding Thompson versus the Federal Bureau of Prisons. Even positioned multiple aisles back, spectators observed its highly professional appearance, correctly secured, structured aligning with Supreme Court regulations, and imprinted using legitimate submission stamps. This application introduces a vital foundational inquiry concerning the Eighth Amendment and national penitentiary environments, she clarified. It necessitated exhaustive review of previous Supreme Court verdicts, comprehensive evaluation of regional disagreements, and the formulation of novel statutory paradigms. She halted, permitting her statements to fully resonate. The sheer scale of her recent disclosures struck the crowd with immense force. Submitting an application for certiorari in front of the U.S. Supreme Court remains among the most intricate and challenging duties an attorney might execute. Such an action demands total fluency in foundational statutes, rigorous adherence to processes, and complete mental dominance. These represent traits Representative Jasmine Crockett had recently demonstrated holding without any shadow of doubt. The application gained formal approval for submission from the Clerk of the United States Supreme Court, avoiding even one demand for alteration or amendment. Each specific element adhered flawlessly to the tribunal's rigorous administrative guidelines, while the enclosed contentions differed from anything the magistrates previously evaluated. Judge Posner, having originally brushed her aside, currently tilted ahead within his seat, observably fascinated against his own volition. Throughout the auditorium, absolute quiet prevailed. Every individual recognized they were observing an extraordinary event, representing an instance of authentic judicial genius occurring directly in their presence. Presently, Judge Posner, Crockett stated politely, her inflection calculated but steadfast, I desire to revisit the comments you delivered previously. The venue became progressively more silent. You designated me a fraudulent attorney, claimed I exchanged rigorous analytical jurisprudence for legislative dramatics, and insinuated I ceased comprehending the actual operations of legitimate tribunals. She motioned regarding the structured pile of records distributed over the desk ahead of her position. The materials I presented today illustrate continuous involvement within national lawsuits, victorious tribunal representation, intricate foundational drafting, and interaction with the supreme echelons of the federal legal system. This does not equate to dramatics. This constitutes jurisprudence executed at the most rigorous standard. The complete atmosphere concerning the altercation underwent a transformation. That which commenced as Judge Posner openly rejecting a representative transitioned into an expert demonstration of vocational legitimacy. Jasmine Crockett had recently exhibited a mastery of statutes that numerous lifelong lawyers might covet. The singular inquiry left unanswered involved how a highly esteemed American legal philosopher might react after being so visibly demonstrated incorrect. The quietness extended for approximately 30 seconds. Judge Posner remained completely motionless, gazing downward toward the stack of proof ahead of him. Eventually, he grasped for his audio equipment. His inflection upon speaking underwent a total metamorphosis compared to the abrasive, rejecting vocalization he utilized previously. Yeah, Representative Crockett, He commenced sluggishly. I owe you an apology. The crowd released a collective breath simultaneously, with several murmuring out of sheer shock. Barely anyone had previously witnessed Judge Posner, an individual recognized for his academic ego and reluctance to acknowledge errors, surrender any point with such directness. Upon labeling you a fraudulent attorney, he proceeded, I depended upon presumptions instead of factual evidence. Such reckless evaluation represents precisely the type of mental bypass I have dedicated my whole vocation cautioning individuals against utilizing. I operated erroneously, and I behaved unjustly. Nevertheless, Crockett had not concluded her remarks. She had devoted several months expecting exactly this sort of confrontation, cognizant that an individual from the traditional faction of the judicial hierarchy might ultimately scrutinize her background. She inhaled profoundly while staring straight toward the magistrate. Judge Posner, I receive your apology, she stated elegantly. Yet I believe this interaction emphasizes a matter substantially larger than merely a misinterpretation involving the pair of us. It indicates a wider problem concerning the way our field characterizes proficiency and capability. Shutting her binder while maintaining her position near the audio equipment, she resumed, You presume that since I serve as an elected official, I necessarily relinquished rigorous judicial duties. However, such a presumption reveals a greater deal concerning our shared prejudices than it communicates regarding an individual's genuine ability or comprehension. She pivoted to confront the spectators, currently communicating holding the assurance of a person recognizing the factual reality supported her position. What number of outstanding attorneys face marginalization due to failing to match conventional paradigms? How many acute judicial thinkers suffer devaluation because they opt to operate beyond the restrictive limits of tribunal litigation? Judge Posner inclined his head sluggishly, appearing observably modest. You remain correct, he confessed. I succumb to the precise variety of rigid categorizing I have condemned over the span of my vocation. I observed the designation of legislator and ceased recognizing the attorneys situated underneath it. Crockett inclined her head, showing gratitude, yet pushed forward. Furthermore, a supplementary assertion requires mentioning, she articulated. The judicial labor I showcased today constitutes merely a minor fraction of the achievements attorneys occupying untraditional positions execute nationwide. She commenced striding sluggishly, her inflection accumulating intensity. Numerous prior state litigators currently serving as senators utilize their tribunal backgrounds to design penal system improvements. Various civil liberties counselors occupying regional departments draft statutes anchored by profound foundational logic. Analytical jurisprudence refuses to terminate outside the tribunal entrances. It progresses and assumes novel structures in any location requiring fairness. Accessing her portfolio a concluding instance, Crockett extracted an alternative variety of record, excluding a submission or tribunal application, but instead a segment of statutory language. Judge Posner, she stated, this represents a statute I independently wrote for the legislature, titled the Federal Court Efficiency Act. It aims to rectify the exact administrative delays you have analyzed within your personal publications regarding legal management. Posner's gaze expanded. He had certainly published broadly regarding that topic inside his volume, How Judges Think, alongside numerous legal journal essays. This legislation, Crockett clarified, constructs directly upon the core doctrines you have championed. It integrates observations extracted from your academic research and implements them toward practical modifications. It avoids legislative concession, rather it focuses on converting stringent judicial theory into functional directives. She transferred the paperwork toward a jurisprudence pupil positioned within the initial aisle who rapidly related onto the platform. Judge Posner accepted the pages and started reviewing them meticulously. His countenance altered an additional time, currently lacking skepticism but displaying deep admiration. The language avoided remaining exclusively statutory in character. It mirrored a profound mechanical comprehension regarding national tribunal operations. The suggested statute encompassed stipulations regarding broadening unconventional conflict settlement initiatives, modifying evidence-gathering protocols utilizing empirically based analysis, and distributing legal assets with greater efficacy corresponding to lawsuit intricacy. Crockett's clarification proved exact and incredibly vocational. Each portion of this legislation, she remarked, is supported by foundational logic, numerical metrics, and verified judicial academics. Zero elements herein are drafted for theatrics, they are constructed to generate practical consequences. Judge Posner glanced upward sluggishly away from the record, his tone gentle yet authentic. This constitutes rigorous labor, he articulated. These modifications directly tackle complications I have pinpointed for decades inside the national legal framework. Crockett inclined her head marginally. Judge Posner, across your vocation, you have contended that jurisprudence ought to remain rooted in pragmatism, proof, and quantifiable results rather than theoretical concepts. That represents precisely what I'm attempting to accomplish, merging stringent judicial logic alongside successful governance. The crowd remained seated in complete amazement. That which they had recently observed functioned not merely as an argument, but as a transformative occurrence, an uncommon and potent signal that authentic judicial supremacy eclipses designations, government, and presumptions.